Right now, there's a man in Texas who just proved something most Americans don't think is even possible anymore. He proved that 9 Supreme Court justices, 3 appointed by Republicans, 3 appointed by Democrats, and 3 more in between minus, can all agree on something unanimously, 9-0. But that's not the shocking part. Here's the shocking part. The exact same law the Supreme Court just struck down, it already ruined one of the most famous families in America. It put a president's own son in a federal courtroom, facing real prison time for something millions of folks watching this video right now have probably done themselves without even thinking twice about it. And the court just said 2 years too late. The government was wrong the whole time. Stick with me, because by the end of this video, you're going to understand a ruling that the news barely covered that could affect your gun rights, your hunting rifle, your home defense pistol, and maybe even your medicine cabinet, and almost nobody explained it to you straight. I'm going to do that right now. Before we get into it, if you're the kind of person who actually wants to understand what's happening in this country instead of just being told what to feel about it, hit that subscribe button. We break this stuff down every week. No spin, just the facts and what they actually mean for you. Now let's get into it. This case is called United States versus Hemani. Ali Danial Hemani, a regular guy, American citizen, dual Pakistani heritage, living with his parents in Denton County, Texas. Nothing about him screams landmark constitutional. Case. That's exactly why this ruling matters so much. This wasn't some gun rights activist who went looking for a fight. This was an ordinary man whose ordinary life collided with a federal law that has been sitting on the books since 1968, a law most Americans have never even heard of until now. Back in 2023, the FBI raided the home Hemani shared with his parents. Agents found a Glock 19, a 9mm handgun. They also found marijuana and cocaine. Now, here's where it gets interesting, and here's where you need to pay close attention, because this is the detail that the entire case hinged on. The federal government did not accuse Hemani of being high while holding that gun. They did not accuse him of threatening anyone. They did not accuse him of being a danger to a single soul. What they accused him of was simpler and in some ways scarier, being a regular user of an illegal drug while legally owning a firearm. That's it. That was the entire crime. Not intoxication, not danger, just the status of being a user. Under a provision buried inside the 1968 Gun Control Act, federal law makes it a felony for any unlawful user of a controlled substance to possess a firearm. Full stop. No matter when, no matter where, no matter whether that person was anywhere near being impaired at the time. A federal grand jury indicted him in February of 2023. He was staring down a felony conviction, the loss of his gun rights for life, and potentially years behind bars. So Hemani did something most people in his position never do. He fought back. His legal team moved to dismiss the indictment entirely, arguing flat out that the law itself was unconstitutional as applied to him. And here's the part that should make every American sit up straight. The federal district court in Eastern Texas agreed with him. They dismissed the indictment. The government appealed. The Fifth Circuit Court of Appeals, one of the most conservative appeals courts in the entire country, upheld that dismissal too. That should tell you something right away. This wasn't a fringe legal theory cooked up by activists. Conservative judges, applying the Constitution as written, looked at this law and said something is wrong here. The Justice Department wasn't ready to let it go. They pushed the case all the way to the Supreme Court of the United States. And here's something that might surprise you. The administration defending this gun restriction in court was the Trump administration. A Solicitor General's office attorney stood up in front of the 9 justices on March 2nd of this year and made the government's case directly. And what was that case? The government argued that disarming regular drug users isn't actually new in American history. They pointed all the way back to the colonial era, to old laws that restricted firearms for what were called, at the time, habitual drunkards. Their argument was straightforward. If the founders were comfortable disarming chronic alcoholics 250 years ago, then Congress today should be just as free to disarm chronic drug users. It's a clever argument. It sounds reasonable on the surface, and all 9 justices rejected it. On June 18th, the Supreme Court handed down its decision, and it wasn't close. 9-0, Justice Neil Gorsuch, appointed by President Trump back in 2017, one of the most prominent originalists on the entire court, wrote the opinion for the full unanimous bench. Gorsuch didn't mince words. He wrote that the government was trying to automatically strip Hemani of his Second Amendment rights based on nothing more than showing that he regularly used some amount of some controlled substance. No proof of danger required, no proof of intoxication required, just the label of user applied for life. And then Gorsuch went after the government's own historical argument, the one about colonial drunkard laws, and took it apart piece by piece. He found that those old laws targeted different kinds of people for different reasons, in different ways than this modern statute does. In plain English, the comparison didn't hold up. You can't justify a permanent blanket gun ban on anyone who's ever used a controlled substance by pointing at old laws that did something narrower and different. The government, Gorsuch concluded, simply hadn't carried its burden of proving this prosecution was constitutional. 9 justices, 0 dissents on a Second Amendment case in this political environment, in this country, in this year, that almost never happens. And when it does happen, it's worth paying very close attention to, because it means the justices found something so clear, so obviously over the line, that even the ones who almost never agree on guns couldn't find a reason to disagree this time. Now, here's where this story stops being just a legal headline and becomes something a lot more personal for a lot of families across this country. That exact law, the one the Supreme Court just gutted, is the same law that back in 2024 led to the federal conviction of Hunter Biden, the son of then-President Joe Biden. Prosecutors charged him with lying about his drug use when he purchased a handgun in 2018. He was convicted under this statute. Just months later, his father pardoned him before leaving office. Sit with that for a second. The same law, the same legal theory, the same federal statute that put a sitting president's son through a criminal trial. The Supreme Court has now said the government applied it in a way the Constitution doesn't allow. Not a small technicality. The core legal theory itself struck down 9-0. This isn't about whether you like the Bidens or don't. This isn't about politics at all, really. It's about something much bigger, a federal law that's been used to prosecute ordinary Americans and a president's own son alike. And the highest court in the land just said the underlying legal foundation doesn't hold up. 2 years too late for one family already convicted, but not too late for everyone else this same law could have reached. Next, how many other Americans, ones you'll never hear about on the news, were quietly prosecuted, quietly pled guilty, quietly lost their gun rights forever under this exact theory, never knowing the Supreme Court would eventually say, the government got it wrong. Here's another piece of the story that almost nobody is talking about, and it's one of the strangest political pairings you'll see all year. The National Rifle Association and the American Civil Liberties Union, 2 organizations that almost never, ever agree on anything when it comes to guns, were on the very same side of this case. Both organizations backed Hemani, both wanted this law struck down. Think about what that actually means. The NRA wants it gone because it's a Second Amendment case, plain and simple. The government stripping away a constitutional right based on a status, not an actual act of danger. The ACLU wanted it gone for a different reason entirely. Civil liberties, due process, the idea that the government shouldn't get to permanently brand someone based on a behavior without ever proving that. Behavior makes them dangerous. 2 organizations, 2 completely different reasons, the exact same conclusion. And when the NRA and the ACLU agree on something that's not a partisan moment, that's a signal. That's the kind of thing that should make every American, no matter which side of the aisle you usually stand on, stop and pay attention. The NRA's top lobbyist said after the ruling that anytime the Supreme Court hands down a 9-0 decision, it gets your attention, and that the government cannot strip away your core constitutional rights simply because you happen to be an occasional drug user. When the gun rights crowd and the civil liberties crowd start using nearly identical language about the same case, that's worth more than any press release from either side alone. Now let's talk about what this actually means for you, sitting at home watching this video. If you're 50, 60, 70 years old, there's a real chance this law has touched your life in ways you never even thought about. Maybe you live in a state where medical marijuana is legal, and you've got a card from your doctor, and you also keep a handgun in the nightstand for protection. Under federal law, technically, that combination has always been a felony because federal law doesn't care what your state legalized. Marijuana is still federally classified as a controlled substance, full stop. Maybe you're a hunter who's used something recreationally on the weekend and never gave it a second thought because nobody enforces a law like that against ordinary people, right? Until they do. Hemani didn't expect federal agents to come through his door either. This ruling doesn't legalize drugs. Let's be crystal clear about that. because some folks online are already twisting this into something it isn't. What it does is say the government can't take away your Second Amendment rights automatically with no proof of danger, no proof of intoxication, just based on a label. That distinction matters enormously if you are someone who owns firearms and also happens to use a substance the federal government still considers illegal. Even if your state disagrees, for the millions of older Americans who are legal gun owners, who hunt, who keep a firearm for home defense, who inherited a rifle from their father or grandfather, this ruling adds a layer of protection that wasn't clearly there. Before, it tells federal prosecutors, you can't just assume someone forfeits their constitutional rights because of a status. You actually have to prove something more. Think about the veteran who served this country, came home with chronic pain or PTSD, got a doctor's recommendation for medical marijuana in a state where it's perfectly legal, and also happens to keep a shotgun in the closet for protection. Before this ruling, that veteran was technically committing a federal felony every single day simply by existing in both of those categories at once. Think about the retired school teacher managing arthritis with a state legal tincture, who also has a concealed carry permit she's held for 20 years without incident. None of these people were ever the danger this 1968 law was supposedly written to stop. They were just caught in the gap between state law and federal law. And until June 18th, the federal government held all the cards. But, and this is important because I'm not here to oversell this to you, the court was very careful to keep this ruling narrow. The opinion itself states plainly that this decision does not address bans on people who are presently intoxicated while possessing a firearm. It does not address future laws Congress might pass if it can show that users of a specific drug pose a genuine, demonstrated risk of misusing a firearm. And it absolutely does not touch the law that disarms convicted felons. That part of federal gun law stands completely untouched. So if you're picturing this as some kind of blanket green light that says drug use and gun ownership are now totally fine under any circumstance, that's not what happened here. What happened is far more precise and, frankly, far more interesting from a legal standpoint. The court said the government can't use a broad, lazy, status-based label to strip away a constitutional right without doing the actual work of proving the danger. That's a much narrower, much more careful ruling than the headlines are making it sound, and that's exactly why it's unanimous. A sweeping ruling that legalized guns for active drug users while high or addicted, and that would have split the court right down the middle, conservative versus liberal, like almost every other Second Amendment case in the last decade. But this ruling is careful, it's surgical. It says, prove your case, government, don't just assume it. And that turned out to be something every single justice, from the most conservative to the most liberal, could sign on to without hesitation. Step back for a second and look at where we are. Because this didn't come out of nowhere. To understand why this ruling matters, you have to understand the road that got us here. Go back to 2008. For over 200 years, the Supreme Court barely touched the Second Amendment at all. Then came District of Columbia versus Heller, where the court ruled for the first time that the Second Amendment protects an individual's right to own a firearm for self-defense in the home, not just some collective right tied to malicious service, like a lot of legal scholars had argued for decades. 2 years later, in McDonald versus Chicago, the court said that right doesn't just apply to the federal government, it applies to every state and every city in this country too. Then, in 2022, came the big one, New York State Rifle and Pistol Association versus Bruin. That ruling threw out the old approach judges had been using for years, where courts could weigh your gun rights against the government's interests in public safety, almost like a balancing scale. Bruin replaced that with something much stricter, a test based on text, history, and tradition. If the government wants to restrict your right to keep and bear arms, it now has to prove that restriction lines up with how firearms were actually regulated around the time the Constitution was written. No more vague public safety justifications are show the historical receipts or lose. 2 years after that, in 2024, the court applied that same standard in United States versus Rahimi, upholding a law that disarms people under domestic violence restraining orders. Proof that the new historical test doesn't mean every gun law falls, and just that every gun law has to earn its place. Hemani is the next chapter after Rahimi, and it's arguably the cleanest example yet of the Bruin test doing exactly what it was designed to do. The government reached for history, found an analogy that looked close enough on paper, and the court said, not close enough. It tells lower courts, it tells prosecutors, it tells Congress itself, if you're going to restrict someone's right to keep and bear arms, You better be able to point to something a lot more solid than a loose historical analogy and a federal statute written in 1968 with almost no precision at all. That's a big deal for the dozens of other Second Amendment cases working their way through federal courts right now. Right now, there are cases stacked up challenging the federal felon in possession law for people with old, non-violent convictions, decades in their past. There are cases about where exactly the government can ban you from carrying a firearm in public, sidewalks, parking lots, private property open to the public. The Supreme Court has been quietly declining to hear a lot of these, almost like it's waiting, letting lower courts wrestle with the new Bruin standard before stepping back in. Hemani isn't the end of this story. It's one more brick in a legal transformation that's been unfolding for nearly 20 years, and it's not finished yet. Before we wrap up, I want to clear up a few things, because the second this kind of ruling hits social media, the misinformation starts flying in every direction. Number one, this ruling does not mean drug users can now legally buy firearms at a gun store. Federal background check forms still ask about drug use, and lying on that form is still a separate federal crime. This case was about prosecuting someone after the fact for simply possessing a firearm while being a user, not about the purchase process itself. Number two, this ruling does not touch felons. If you have a felony conviction on your record, federal law still bars you from owning a firearm, and nothing about this decision changes that, regardless of what you might see claimed online. And number three, this ruling does not mean you can be intoxicated and armed without consequence. Being actively impaired while in possession of a firearm remains a completely separate legal question. One the court explicitly said it was not deciding here. What this ruling actually does is much narrower, and honestly, much more American in spirit. It tells a government that before it strips away a constitutional right, it has to prove its case with real evidence, not a convenient label slapped onto an entire category of people. So here's where that leaves us. A regular man in Texas facing federal prison time over a law almost nobody had scrutinized in decades, took his case all the way to the highest court in the country and won 9-0. A law that already convicted a president's son got dismantled 2 years after the fact. The NRA and the ACLU, who agree on practically nothing, stood on the same side of the courtroom. And the Supreme Court drew a careful, narrow line that protects ordinary Americans from having their constitutional rights stripped away based on nothing but a label, while leaving the door open for Congress to come back with real evidence if it has any. This is the kind of story that should be on the front page of every newspaper in this country. And instead, most people watching this video are hearing about it here for the first time from me. 9 justices who disagree about almost everything looked at the same facts and reached the exact same conclusion. That doesn't happen by accident. And it shouldn't be buried on page 12 of the news. That's exactly why this channel exists. Not to tell you what to think, to give you what actually happened. Straight, so you can decide for yourself what it means for your rights, your family, and your future. If this video gave you something you didn't have 5 minutes ago, do me a favor, hit that like button, subscribe if you haven't already, and drop a comment telling me what you think this ruling means for gun owners going forward. I read every single one. I'll see you in the next video.